Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Well, hello everybody. Welcome back. Welcome back. Welcome back to J is for Justice. My name is Jay. I am your host. Thank you for joining today. We're going to be watching the last motions hearing for Sarah Boone before she goes to trial. Her trial is set to begin October 7th. And we have all of the events up for the first 3 days. So when this is over, you'll actually get redirected to the event for day 1. And you can hit the notification, and we will begin streaming on Monday. So we're going to be streaming this entire trial, day in and day out, and we will not miss a moment. So welcome in, everybody. I hope you're having a good day today. Did she get approved for the skirt is what I want to know. Did she get approved for the skirt? I want to get your comments up here. I have to take care of something when it first starts. I'm going to be listening, but just know that I'm not looking at the chat. Jenny's Chaos and Crime. Thank you for buying a cigar. Much appreciated. Much appreciated. Is that a joint or is this a cigar? So scrolling across the bottom will give you the information that you need to know about the upcoming trial date, etc., etc. I am so happy to see you guys today. You don't even know. You don't even know. Oh, we got a birthday? Fixing to start my birthday, Jenny. Chaos and Crime. Thank you. I didn't see your message. Let's do happy birthday to Jenny. Jennifer, happy birthday.
Go, shorty. It's your birthday.
Happiest of birthdays to you and everybody else. Because yesterday was the first of the month. It's the first of the month. Yesterday was the first of the month. We were on the other channel. It's the first of the month, so happy birthday to all the October babies. We're going to party like it's your birthday. Aw, you're welcome. Have a great day. And all of you October babies. Hello, Miss Cheryl, Auntie Cheryl. You guys can always use best mods. That's a new command. Just to thank the mods if you ever want to just give them a thank you. If you're watching and you're like, damn, these mods are hardcore. Hard workers. Go ahead and put best mods. Good morning, Gypsy. Melissa B, it's good to see you, honey. Good to see you, Rhonda. I am a Scorpio, so I'm about a month away from my 51st. It's bananas. Okay, let's get your comments pulled up. So I want to be able to... Oh, I'm sorry that your mother passed away on October 1st in 2017. I lost my mom in 2019. So I feel you, GB. I do. I'm really sorry for your loss. It's never the same without mom. I'll tell you that. I'm 100% on board with you there. I miss my mom every day of my life. November the 7th. Nice. We're getting lots of thank yous to the mod crew. We really have the best. We have like a reputation here on YouTube of having the best mods. And I can't take credit for that, but here we go. We are live in the courtroom. We don't have audio just yet, but we are live with Sarah Boone's motion hearing. She's going to be asking if she can have a hairdresser, a professional one, for her trial. I'm not sure if the skirt issue was resolved. I missed that one. And then she's also, I think, trying to get rid of some of the evidence from the interrogation video. So she's trying to get some of that thrown out as well. And that's pretty much all I know. So I'm just working on getting our chat screen pulled up. And we should be starting in just a second. Oops, wrong one. There we go. All right, guys, now we can pin our comments while we're watching the stream. And if you haven't hit that like button, now would be a great time to do that. And I just want to thank you in advance for being here to watch this hearing with me. And like I said, on Monday, we will begin. I'm not sure if it starts right at 9. I have the event for 9. But we will be streaming the Sarah Boone trial beginning to end, starting on Monday, October 7th. So this is Judge Michael Kranick. Hey, Yins. To Jay and Yinzal. What's up, Pine? Croc Charlie, what's happening? Kaleidohope, good to see you. Casey Marie, always lovely to see you as well. Sarah, we've got Black Eagle, good to see you, honey. Spanx. I wonder if she's going to wear a skirt. Damn, Cheryl, I didn't know it was your birthday last month. Hey, Nicole. Happy belated Auntie Cheryl. Can you see her, though? In her skirt with her, and sorry, my lighting is so dim. I actually have my light on all the way, but, I got my window shade open, so it's like really bright over here, and my light's just not, it's on. Let me turn this lamp on. Very yellow. Anyways, whatever. It is what it is. Hey, Megan May, welcome in. Good to see you. Good to see you. Hey, Chris, it's good. Oh, I got to put it on live chat. Jenny just gifted a J4J membership. Let's see who gets it. Hazel Eyes, welcome to the Clickers. And thank you, Jenny. And make sure you thank Jenny for that special gift. Thank you so much. Oh, wow. 30. That's young, Auntie Cheryl. Well, why would she want to wear a skirt, though? Yeah, I'm going to be 51, y'all. I got 2 grandbabies. I got 2 of them, grandbabies. You can see me. It seems like it's dark, but like I said, it is what it is. Are you guys all decorated for Halloween? Are you guys big Halloween decorators? I was really shocked when Potato told me in UK it's not a big deal to decorate, and they don't really, like, their Halloween in the UK is not like it is here. And if you notice, we have a new way to support. By popular demand, I was asked to put up a buy me a coffee. So it's buy me a coffee or a pizza. If you guys want to check that out, it is a way to support the stream, and I appreciate you. And thank you to those, you know who you are, who suggested that I put up a buy me a coffee. Melissa B. I have enjoyed modding, helping mod on every day. We really have the best community on these streets. I appreciate you modding on every day. I really do. All of you guys. And thank you for your super chat, Melissa. I now have new goals for the 50s is the new 30s. Did you know that? I did, Chris. I was just listening to it and I can't stand Wade Wilson. Oh, if no one sees it, I can see. Hey, Brenda, welcome in. I can't afford decorations right now. I love Halloween. I know. And that shit's expensive. Miss Odin, do you have little ones? Hey, One-Eyed Flo, where the hell have you been? Jess N, good to see you as well. You turn 50 tomorrow, Amy. Amy has the big 5-0 tomorrow. No, embrace it. Your 50s, you're so much smarter than your 40s. I didn't want to turn 50 either. Trust me. I don't like saying it. You do have little ones, Miss Odin? I would love to like help you out and get you some Halloween decorations so you and your little ones can decorate. Can you send me an email? Maybe Miss Odin, you can make a Amazon wish list for decorations and I can share it. I want your kids to be able to celebrate Halloween and decorate. I'm glad you feel at home. I'm glad you feel at home, Rhonda. That's absolutely what I aim for. Happy early birthday to Amy. Amy, were you here when we played birthday? If not, here's a birthday for Amy. In case I don't see you tomorrow.
Go, shorty. It's your birthday.
Oops. First of the month came up. Happy birthday again, Amy. Not sure how to do that, babe. Let me know. Email me. And do you have the Amazon app, Miss Odin? Because that would be really easy for everybody to just purchase stuff off the Amazon app. Hey, femme. I'm cleaning out my closet. Yes, Flo, absolutely. I told you that. But you have to send it to my house, Flo. Thank you. Flo is hooking me up with an iPad. I could stream outside. I'll be able to stream from the pool or the beach. I could take you out with me. But Miss Odin, please send an email here. Send me an email here. Not to the main one. Hey, Kelly, I hope you're doing good. It's okay. I'll help you. I'll walk you through it. Email me there, and I'll hit you up this evening, and we will get your kids some Halloween decorations. I know how tough it is, man. But you know what? I look back, and I think my kids always had shit to put up and stuff, and I know that times are tough right now, and they weren't when my kids were little. You know, things were a lot easier, and just the fact that you have little ones, I want to help out. Or Halloween costume stuff, whatever it is. Let's help out Miss Odin for Halloween. New Amber Alert in Texas. Really? Let me check that out. Believed to be in grave danger. Oh, this is, wait, is it the baby? There's several in Texas. Zoe. Okay, this one's today. Hurst. Okay. Why can't I click on it? So it's Zoe Roth I'll stick the flyer up here. It looks like they're getting ready to start. I don't know, they're moving around. We still don't have audio. Okay, here it is. We'll show you this because this is obviously important. We have a lot of Texas people. We'll get right back to the stream, guys. Thank you for letting me know about this. Hearst Police, you're in Texas, issue local Amber Alert for 16-year-old girl missing. Zoe Robotham, 16, was last seen at the intersection of Blue Bonnet and Arwin Drives in Hearst about 8:30 p.m. on Sunday. A local Amber Alert was issued Tuesday for the North Texas teen. Police described her as a high-risk runaway who has a diminished mental health capacity and is in need of medication. She is about 5'6", 240 pounds with brown hair and hazel eyes. She was last seen wearing a black t-shirt with white lettering, black basketball shorts, and white shoes. Anyone with information is asked to contact the Hearst Police Department at 817-788-7180. A 16-year-old girl with special needs. Hearst, Texas. Hearst is a nice area. Is it a busy place? You have 3 girls? Oh, how old are they, Miss Oden? I know, it's very scary. Miss Oden, what's your Venmo, honey? Put your Venmo in chat as well. Let's help out Miss Oden today. If everybody sends $1, if we have 100 people send $1, she has $100 to go get Halloween deco, and she has 3 little girls that, would love to celebrate. It's good to see you, Healing Nature. Hey, Cricket. Click clock. Oh, Miss Oden. They're 11, 13, and 15 and struggling because they lost their daddy. Oh my God, I didn't know that. I'm so sorry, Miss Oden. Raphael, where is that? Hi, Tracy V. Thank you, Crimes, for letting me know. So her Venmo, okay, let's put this up in chat. Thank you, Lala. I appreciate that. Sarasara, I'll help her with the Amazon wish list. Okay, there we go. Oh, at Crystal Oden. I forgot the at. But it's at Crystal Oden. I can't edit it. Thank you, everybody in advance. We are definitely a community here. We're a family, you know? Aw. Don't you cry. Don't you cry. I know, Jess. I've missed the trial watches. This one's going to be a good one, too. We also have one of our moderators, Miss Robin. She is without power and without internet in South Carolina. She is okay. She is safe. but supplies are limited in their area, and they have no electricity and they have no internet. But I wanted to let you guys know that one of our own, is stuck in this mess. Angie did it was great how we did. Oh, you don't have to be embarrassed. We all have our struggles, girl. Hey, Melusine, Portugal. That's awesome. Welcome. What's up, Pearl Girl? Aw, Hazel, that's sweet. But yeah, we did for Angie B's grandchildren. We did an Amazon wish list, and it turned out awesome. They got everything on their list, I believe. Oh, I know, Miss Robin, and they have no idea when hey, Speedy, when they're going to get power back or anything like that. So if you guys want to help out, we have we're going to help Miss Odin today. She has 3 little girls that want to celebrate Halloween this year, and things are tight. They've lost their dad. So I hope that we can help out today. Bunny, that was so nice. You guys are awesome. And maybe Angie can help with the wish list too, Miss Odin. And you know what? We never know what anybody's struggles are. So if you don't say anything, we don't know, So I'm glad that I was able to ask you that. What was I going in Discord for? I was going in Discord for something. Yeah, and never be embarrassed. Exactly, Pine Needle. She said, dude, don't ever be embarrassed for needing help when you're trying to make your kiddos' lives better. Especially when you're adult hands that, you don't have any control over. So her Venmo is at, and then it's pinned. Crystal Odin. Hold on. Your daughter is having her 5th child on the 10th. Please say a prayer because the baby is early and they're saying my daughter can bleed out and she has nothing for the baby. How early is the baby? Trina will pray for, it's my daughter's birthday is the 10th. Hey, jammers. We will pray for her, Trina. Hold on. Oh, Maggie. Hold on. Maggie doesn't have Venmo, so I'm going to send mine and Maggie's together because I was just sending you a little something. Okay. I just want to get this to Crystal Odin. There we go. Crystal, I just sent from... Hold on. You may not even need an Amazon wish list after this. Thanks everybody for helping her out. I did too. So that's from myself and Maggie B. Thank you, Mags. Court starting? Why don't we have audio? They have, I know, but we don't have audio yet. It's still quiet. Aw. That'll be awesome. Let us know how it goes, Miss Odin. Boone, Shalock Boone. Oh man, Kelly, I know everyone's going through it. You lost all your food? Do you have food pantries near you, Kelly? I know we have a bunch of them. I don't know where you're at, but I can help you search. Will she demand hair extensions? I don't know. See, the judge isn't in there yet. They don't have the audio up yet. But we're here for it. There we go. Oh my God. That just hurt my ear. What the heck? There's her lawyer. Look at her hair. I know. Look at the back of it. Oh, I'm glad, Tracy V. Hopefully that makes you feel better. Oh, hey, Jen. Glad to have you. Hey, Danielle. It's definitely like the Dorothy Hamill. So this is the last hearing until trial on Monday. I'm in South Georgia. The National Guard is giving out water and ice, otherwise not in my small town, Enigma, Georgia. Water and ice? Nothing else? Do you guys have power, Kelly? Oh, he was? Oh, because he didn't respond to that motion. Oh, this ought to be interesting. I don't know, Cheryl. Maybe she will get some extensions. I can't with that haircut, y'all. The back of it. Oh, I can't with her. Yeah, I know. That's why I was going to do a fundraiser, but I don't trust those organizations. I don't trust the Red Cross. Oh, Zoomer mom, that's so sad. Hey, Stacy. I mean, she could at least like try to thin that shit out in the back. Oh my God. I just laughed like a total fucking dork. I don't even know where that came from. All right, guys, I'm going to go off camera for a few. I am here. I'm listening. I'll still be talking, but I have to take care of a couple things at my desk. So I'm here, but I got to go get my laptop. So I will be RB. What? I want to that killer again. Well, I got it on Amazon. I don't have it yet. I don't want it. Okay, you can wait to get through. Okay, sorry. We're trying to get our gutters fixed before this next storm comes our way. If it does, I don't even know. But anyways, we're trying to get our gutters fixed from the storm. Hey, Janae. Oh, do you all think it's an accident? Let's do a poll. She's going to use the abused spouse what is it? Abused spousal defense or whatever. Abused spouse defense. Gutter cooter? I am a gutter cooter. We got to get some special screws. There you go. Get your votes in. Battered spouse. Thank you, Sarah, Sarah. Sarah, Sarah. Melazine, what's for dinner? What's for dinner? Oh, Lord. Now we have red tide found in the water at the beach here in Clearwater. Oh, from St. Pete Beach to Dunedin, there is red tide found in the Pinellas County waters. If she cuts it herself or not. Well, I mean, it's either her or one of her girlfriends in jail, right? She's in with General Pop. Hey, say no to globalism. I hope you're doing well, honey. We miss you too. Danielle says, no, this was no accident. Hey, Rach. Red tide is like it's an algae type thing in the water, and it kills fish. It makes you sick. It gets in the air, and it causes respiratory symptoms. So, like anybody who has a vacation to the beach, you ain't gonna want to go in the water. She asked for hair and makeup. Yeah, it's basically from poop. It's disgusting. The water is definitely not as pure as we thought it was. What's up, Lily? Ooh, some bacon and eggs for brunch. Let me go enjoy my sausage and pretend I'm a responsible adult. Go enjoy your sausage. It depends on what kind of sausage it is. My daughter's last baby will be a year old on the same day as this one is due. Oh, wow. My daughter's birthday is 10/10 as well. She was born on 10/10 she turned 10 in 2010 on 10/10. Say that 10 times fast. We need some mic action. We're not going to get our hot mics this time. Brown tide. We get red tide every year. It's disgusting. Do I think she gets along with this lawyer? Probably. 20 minutes, Lily. And they're literally plowing sand off of the roads and stuff. All right, here's the judge. Judge Michael Kranick has entered the courtroom. And just FYI, on Friday, we're going to go over the sheriff who shot and killed the judge in his chambers. We're going to go over that case on Friday Live. Here we go.
Clerk, I'm ready when you are.
Oh my gosh, this audio.
David Ketchner on behalf of the state.
William J. for the state. James Owens for Sarah Boone.
Jesus. Come on.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record.
Kidding
for
me?
Sarah Boone, 10-10-7-7.
Okay, we're here
She's
on
10.
several different matters, including a motion to suppress, specifically the motion to suppress defendant's statements at OCSO filed September 24, 2024. The amended motion to suppress defendant's statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant's statements at OCSO. State, have you had the opportunity to review the second amended motion?
Yes, sir.
Are you ready to proceed on that today?
Yes, sir.
Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedures.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yes.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian, and clothing without restraints for trial, Mr. J., do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or is it
Yeah,
something else?
if you
They need to turn on their mics. We can't hear them.
in the very back. If you look in the very back,
Okay.
you see the Miranda card. It's the last page and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes. I also have reviewed the 2-hour and 6-minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification. It is a DVD, courtesy copy. It's the body worn camera.
Hey, if you're just joining, thank you for watching on J for J today. We are waiting for the proceedings to begin.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection?
What was pre-marked as States A will be received into evidence without objection as States 1. Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle. Chelsey. Last name is Koe.
Okay, this is not going to work.
SELL.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am homicide.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So, for this case specifically, my team was on call that week for homicides. And so, the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet.
Their audio's horrible, y'all.
But I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first, or do you do anything else?
For this particular incident, I got my partner, Detective Scott Owen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes.
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it was more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else, and then once that was executed, we went in there further with CSIs, and then we talked to Brian Boone, which was the ex-husband, and then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior, and there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview.
Well, look at her
on that
microphone. It's not
recording,
even
did you
near her
not?
mouth.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, it's not.
Okay. At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise in relation to talking to her?
Well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs, and so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but she was able to leave.
Prior to that, had she been detained and requested not to leave the scene?
One more time?
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potentially child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then, if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right.
Whoa, did you just hear that
Now,
voice?
in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay, and they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and
Thanks,
I
Flo.
have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone?
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form, Sarah, give me the password to your phone?
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived?
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
She's sassy.
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen.
Correct.
Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Relevant.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
Right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's fine. You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
I'm sorry?
It's not on my Miranda card that I'll read from, but you can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card.
She needs to turn on her
I
mic.
have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy, yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there's that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
This is going to be entertaining, guys.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No,
You did not tell her that?
no. I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's
Sarah
department the
Boone.
next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines, yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Agent Cooter.
Sustained.
Agent Cooter cough.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it, though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know off the top of my
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
head. Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I probably didn't get there till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowen was with me or not, but yes, of course, there's doctors there.
Okay. And so, in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the
Did you hear that
sufficiency of
woman's
Miranda
voice?
and coercion, what does the formulation of probable cause have anything to do with anything?
Oh, Lord.
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the 3 issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
Oh, Lord.
My response,
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway?
Correct.
And that was based on your investigation that you had the night before at the scene. And it was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance as to what the probable cause basis.
Sustained.
You had all that
Hairdo.
information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th?
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the video, the 2 videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time?
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, "I'm going to have you sit in the green chair"?
Objection, best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, improper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
I did see that one-eyed Flo. I heard that yesterday. It's really sad. Thank you for the pizza, Kelly.
Objection, relevance.
They are not liking this guy, are they?
You may.
See if you recognize that document.
Yes, this is our waivers and affidavits.
And is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do. We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature or what?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
And that is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read or Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, no.
Okay, you would agree that there's 9 questions on that Miranda?
Yes.
Whoever would like to offer this?
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this
Amy,
state
thank you
through
for
the
the
14th
pizza.
Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Your response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda, and that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one, one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay,
Oh,
let me
Lord.
finish my argument.
Okay.
She has a duty to read the rights.
Thank you so much, Amy.
She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr.
He's
Chair?
either 8 or 9.
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in
Hey, gone,
Thomas
girl.
351, 7th 3rd 197, and Owens 41, 7th 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
Uh-oh, what just happened? Uh-oh, they lost their feed? Are you kidding me? Come on. Who is this, Lawn Crime? What happened? Let's see. Is Court TV live with it or what?
read her those Miranda rights?
Oh. Same-ish. They just froze up. Are you kidding me? Like, what timing is that? Redonkulous.
From the situation
Oh, we're
the day
back.
before when you read a Miranda in the squad car.
Their feed.
That was without the autopsy.
Is this
That was
2024?
without
What?
The 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Their connection's awful. I don't know why either. Boone, shalak lock, boom. Do you need a cough drop?
I don't want to see you
Oops.
again for the rest of my whole life.
I don't want to
wanna
see anybody else either.
That's all the questions I have at this time.
Any redirect?
No, thank you.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you.
I'd like her to
State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the card.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
Can't hear him. You will, Ange. Yeah. They need to get lapel mics in the courtroom. Thanks, Flo. Flo just gifted a new clicker membership. Make sure you thank Flo if you are the lucky recipient.
Or down your pants, you're going to pull that out.
It was Meep. Meep, make sure you thank Aunt Flo. Thank you, Flo, for being so supportive.
What is it that's been marked as Defense Exhibit B?
Judge, it's the-
I mean, I can see that their internet might be shaky, but the audio is strictly the mics, I think. Hey,
Any
Megan.
objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the... Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Cootersville?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
Easy board down
All
your
right, I'm going to sustain the relevancy objection for the same
10
reasons the
months.
court articulated previously.
Me too, retired. I'd be like, I'm done.
And Mr. Owens,
Oh,
you
he
had
just-
one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
He just patted on the back. She loves him. She loves this lawyer, I bet you. He's given her everything she wanted. She wanted to be babied. Good for her for, not giving up. Sherry, thank you so much for your $10 super chat. That is so generous of you. Thank you. You guys thumb up Sherry's super chat.
Do you know what page specifically those policies are on?
Page 14.
Very kind.
22.
Hey, Sarah, a Christmas bell called. It wants its
Is
shape
it
back.
beginning of paragraph 4, waiver of constitutional rights?
Yes.
Where's the bell in this emoji? She's got her hair shaped like a bell. I had one of those cuts in junior high school, y'all. Heavy on the bottom. I'm trying to find the bell. I'm on my computer. I can never find emojis fast. Sin is like the emoji queen. Can we get a bell
I've
in
read
chat?
pages 14 and 15.
All right, Judge, and then you go to 13 of 28?
Here it is.
13?
13, hey, well, it's the next.
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
It's
There
split
it
up.
is.
Got it.
13 of
Dreams got
28
it.
at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
The bell. Or that head. I mean, not that I have a whole lot of room to talk about heads, but it's so funny. We're going to be celebrating Halloween periodically throughout
Anything
the
else?
month.
Anything further? Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Oh,
Ms.
Sarah.
Boone can approach the podium.
Sarah. Sarah.
She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
I gotta disconnect my hard drive. Hold on. It makes my shit lag. Please work.
Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Whoa, guys.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state.
Bring it all in.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained, and it's stricken.
All right. Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the 2 detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to include anyone.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove.
Okay. What was the reason that you wanted to stay over there the night?
Because I was terrified of his family.
Now, later that evening, you were going
Not
to spend the
that it was
night there with
creepy
your
to be in the
son
house
and with
where
your
he
ex-husband?
died, but scared of the
And
family.
did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know what's pending and how to object to it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did.
How did y'all get upstairs?
In an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the
Thank
elevator?
you.
Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Sit down.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Hey, Potato.
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol.
Coming in hot with
To her.
some membership
I reiterated
gifting.
to her what she had said to me the day before.
Welcome, new clicker.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
You're welcome, guys. Make sure to renew at the end of the month,
The way
y'all,
that
if you like
she-
your membership.
Acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, she's in custody.
Sustained.
Hey, Global.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial
Okay,
interrogation.
but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective
What?
perception matter?
Well, Under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to whether or not.
Let me finish. She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol.
Blame it on
under
the
influence or impaired.
The objection is,
alcohol.
the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw it.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge,
Regarding the.
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all of the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
Is she shackled?
Okay.
Let's see.
Anything else from the state
She's
other than
handcuffed
argument?
today.
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Thanks for being here, Nicole and everybody else. Her trial begins Monday morning, Monday, October 7th. The event is up and you'll be portaled there to hit the reminder after this live stream ends. Portaled Cooters.
Judge, my understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions.
Ask me
Once
no
that
questions,
happens,
and I'll tell you
law
no
enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him.
Oh, Lord.
The law allows law enforcement at that stage to use deception, to lie, to trick.
Oh, Lord.
We found the murder weapon. It's got your DNA on it.
You going to want to
Your
represent Brian
co-defendant has
Koberger
come in
next?
here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal.
He's saying what they did was illegal.
So you got Detective Kopsel on the one hand.
Kopsel.
I got to read your rights. And you have a right to remain silent.
He's so dramatic.
But within a minute before,
Probably crimes, yeah.
the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to. Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Aw, I'm glad you're here, Charlie.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. a traumatic event. She lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights.
Just need to do it.
Right there within a few seconds of each other. That's improper, it's illegal, it's coercive.
Trip.
It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the 9th question.
The 9th question.
If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's, and of course she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday, The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Jim, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record?
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without
Cosmetics?
restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification, but, you know, she's here today and she's in handcuffs, so she has difficulty writing, she has...
Let me just interject for
That's
1 second.
already been handled, right?
She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I, and the only time they're going to see her walk in and out is she's always going to be in the courtroom
They're
first.
never going to see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny, and she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here?
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay.
Beliefs.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial, just the arguments in there.
And Estelle case that you spoke to being dressed out in a prison garb. It doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
Beautification.
I just think it's, it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along
Use
those lines.
Kool-Aid.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom.
Oh, my
I'm sure there's a
God.
waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
She wants like a dressing room.
Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine.
She's gonna get it.
But be advised that, when we start court, we start court.
We're gonna see her getting her face
and
did
I
every
intend
day.
on starting at 9 o'clock every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter.
God. How would
So
you
your
like to be a
motion will granted
lawyer
with
and now be a
regard
glam
to
artist?
The clothing, you can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed.
Judge, and then I think there's something about hair as well.
I think that it falls under the same
Okay.
analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry, yes. Yes.
Did we get muted? She's going to have a smoky eye. Oh my God.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined. After she's returned to the Orange County Jail.
Oh,
facility.
thank you, Life's a Beach.
Okay.
You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think
All y'all.
last week after it was filed, and
Oh,
said this would be
no.
added to the hearing for. I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing and listing the, I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to. where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You'll have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, State, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow? Yeah. And that will be done virtually?
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
All right, guys, that is it until trial. So tomorrow what I'll do is I'll check and see when the judge puts his decision and it's filed by the clerk, and we can go over it. I don't know why they have a court date or a holiday. What is tomorrow? Rosh. Oh, tomorrow? Wait. Rosh hash. I don't know how to say it. Hashanah. Rosh Hashanah tomorrow. So we don't know. There'll be all of these decisions will be done in writing, and the court will file it with the clerk, and then we'll be able to tell what the judge decided. So I'll be checking that tomorrow. Until then, I will see you guys in the next one. Thank you for being here. You are going to be portaled over to hit that reminder after this live stream ends. Thank you for being here. I hope you decide to watch the trial with us on October 7th, Monday. We have a lot of fun doing trial watches, so I'm really looking forward to it. We haven't done one in a long time. Thank you guys for buying me coffee and pizza. I will see you in the next one. Let's roll our credits, Myron. So much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further?
Bring it all in.
And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click, 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 click. It's real easy, man.
You and your problems, I don't give a damn. You talk way too much, I have heard enough about you and your problems. I don't give a damn. 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 You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I'll never call you back. 'Cause I ain't got time, I ain't got time, I ain't got time for that. I don't give a damn, I don't really care about you and your problems. I don't give a damn. You talk way too much, I have heard enough about you and your problems. I don't give a damn. 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 I don't know.
What the French call les incompetents.
You're mad at me for not giving you comfort. You say that I'm away so much and now you don't feel the way you felt when we were younger. But that's okay for me. Cause I don't give a damn. I don't really care about you and your problems. I don't give a damn.
Everybody does that. It's okay.
You talk way too
Thanks so much, Jennifer.
I have heard enough about you and your problems. I don't give a damn. 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 I don't give a damn.
Bye, Jennifer.